Undue influence is one of the most common claims we see here at Bernstein Presnell for will and trust disputes. To prove undue influence, you must first show a person is subject to influence. 2, there's an opportunity to exert influence. 3, that person has a disposition to exert influence. And 4, there's a result that indicates undue influence was present. So what does that mean? Essentially, undue influence occurs when person A influences person B to such an extent that the wants and desires of person B are really the wants and desires of person A. So let's break this down even further. Courts have given us a list of factors to determine whether undue influence is present. First, we have the age of the testator. So, was the testator 66 when they made the will, or were they 96? Second, the physical and/or mental weakness of the testator. We see a lot of cases where the testator had advanced Alzheimer's or advanced dementia at the time that they made the will. In those cases, there's usually strong evidence that the testator was physically and/or mentally weak at the time that they made the will. Third, whether the person accused of undue influence was living with the testator at the time that they made the will. Fourth, whether the person accused of undue influence exerted control over the testator. So did they constantly supervise the testator? Would they not let the testator see anyone else without them present? Fifth, whether their prior will is different from the will being disputed. So, for example, let's say in 1998, you get 1/2 of your father's estate. But in 2001, he makes a new will, and now you suddenly get nothing. 6, whether the will favors a non-family member. So this could obviously be a caretaker, a friend, a neighbor, anyone not related by blood. And then 7th, whether the person accused of undue influence played a role in making the will. So did they set up an appointment with the attorney? Did they take the testator to the attorney's office? Did they pay for the attorney? Did they take the testator from the attorney's office? Or did they draft the will themselves? Now, these are just a list of factors that the courts have given us to determine if undue influence exists. None of them are outcome determinative. However, obviously, the more factors that are present, the stronger a case is for undue influence. As a disclaimer, you and I have not formed an attorney-client relationship, and this is not intended as legal advice. However, if you think that you have a strong case for undue influence, or if you find yourself defending a case where one of the claims is undue influence, we strongly recommend that you talk to an attorney who handles estate litigation matters. Thank you so much for taking the time to watch this video, and we hope that it has been helpful.